Joining me now is Jon Meacham, historian and Rogers Distinguished Professor at Vanderbilt University. John, what is the long-term implication of this in terms of the court and in terms of the rule of law if 5 members now of the Supreme Court can overturn nearly a half-century of constitutional precedent?
You know, Andrea, we're entering an unfolding crisis of trust. It's unclear what the implications will be, but I think we can speculate with some safety that an extraordinary number of Americans are going to see this as a startling and maybe they shouldn't be surprised, but they will be, reversal of a half-century of precedent. Now, precedents should not stand just because they're precedents, but as you just played, there has been an understanding in the country that the 1973 decision, or at least the rights secured by it, were secure. And, you know, one of the things we're going to have to deal with here is we're such a narrowly divided country. You know, we've only had 3 presidential elections since World War II where a candidate got even as much as 60% of the vote. And we've been in an era where we're much closer, as we know, to having popular minority vote winners become president. And so we're narrowly divided. And if a narrowly divided court makes this sweeping of a decision, you're going to have an extraordinary number of people in the center and to the left of the spectrum. And I hesitate even to talk in those conventional terms, but for these purposes, in the center and to the left, believing that this was a political as opposed to a constitutional decision. And you know, when Earl Warren led the court in 1953-54, announced in May of 1954, to the Brown versus Board of Education decision, he took care to make it a unanimous decision, 9-0. And so when big stuff happens, history tends to suggest that you don't have this on a 5-4 decision.
Jon Meacham, when we think about other constitutional rights that have been conferred in recent decades, and that includes Republican decisions as well, the right to marriage, that the majority opinion was Justice Kennedy, the mentor, of course, of Justice Kavanaugh on this court. What does this mean for the right to contraception? Because basically the privacy right undergirding Roe was Griswold in Connecticut, and that was the right to privacy, and then by extension, of course, the right to marriage. So what does this mean for LGBTQ rights?
I think everything is at risk. And, you know, people like me, and I don't want to drag you into this, but people who do what we do for a living often say that democracy is a fragile thing, that the Constitution is a fragile thing. Well, if you ever thought that was hyperbolic or a cliche or some sort of casual thing, read this draft opinion. Elections matter. The court matters. The composition of the Senate matters. The presidency matters. Because in a republic, all rights are supposed to be eternal, right? They're supposed to be grounded in the both in reason and in a theocentric view. They're supposed to be eternal, but in practice, they're temporal. And what we're seeing today, in vivid terms, right where you're standing, is that the rights that many people have taken for granted for 50 years and more are fragile and at risk.
Jon Meacham, as always, thank you so much for your perspective.